by trying to put in context for you what is Article 97 and kind of build the legal framework within which Article 97 is interpreted. And then Kathleen's going to get to what we're really all here for, which is kind of the more practical aspects and applications of Article 97. But I've referenced here the case of Smith v. City of Westfield, which was about a year and a half ago now decided by the Supreme Judicial Court. So kind of bringing you up to speed with where we stand up to and following the court's decision in the case of Smith v. City of Westfield. Quick plug for my law firm, McGregor & Legere. We're in Boston. We do all manner of environmental law and land use law. So Article 97, what is it? It's an amendment to the Commonwealth's Constitution. What it does is essentially codify a common law doctrine known as the public trust doctrine, which essentially says that the sovereign holds land with various natural resource purposes or values for the public in a trust. It was enacted in 1972, and as you can see here, it essentially grants to the Commonwealth's citizens a right to clean air and water, freedom from excessive and unnecessary noise, natural and scenic and historic beauty, and so forth. So again, just quick background. The purpose is codify the public trust doctrine, create that duty within the Commonwealth to conserve, develop, utilize natural resources. And here are some of the key provisions of it, granting to the Commonwealth that power to provide for takings, strengthens its predecessor, which was known as Article 97. And most importantly here, this final point, it requires a 2/3 roll call vote of both houses of the legislature if land is going to be taken out of Article 97 purposes or used or designated for another use. So prior to the recent decision in Smith v. City of Westfield, it was a little murky. And when I say it, exactly what the legal framework for Article 97 was a little murky. There was kind of some gray area there. One of the reasons was a case that the Supreme Judicial Court had decided in 2005, known as Selectmen of Hansen v. Lindsay. This was a case where the town of Hansen acquired property through a tax taking. Town meeting subsequently voted to authorize the Conservation Commission to accept a deed for that property for essentially conservation purposes, but that never happened. The deed was never executed. There never was that transfer. Move down the line, there's a sale of the property. Question arises, can you do that? Can you transfer this property, which we, the residents of Hansen, think was designated for Article 97 purposes? The court ultimately says no. The Supreme Judicial Court says no. There was no Article 97 protection here. The town meeting vote in and of itself was not sufficient to confer Article 97 protection on this property. Had the deed actually been executed and recorded, sure, then you'd have Article 97 protection, but that never happened here, so that town meeting vote standing alone, not enough. More recently, 2013, the case of Mahajan v. Department of Environmental Protection, another Supreme Judicial Court decision dealing with Article 97. This case was one that I was involved with at the Supreme Judicial Court level. We represented the plaintiffs there. We hadn't represented them up to that point. And just briefly, the background of the case was that Long Wharf in Boston, which some of you may be familiar with, was part of a larger area of land taken by the Boston Redevelopment Authority, the BRA, for a variety of purposes. One of the purposes listed in that taking generally was outdoor recreational uses, park-type purposes, but they didn't specify what portions of the area taken needed to be put to that purpose. Long Wharf, the very end of Long Wharf, the water end of Long Wharf, ultimately became a plaza. There was an open-air pavilion out there. There were the coin-fed binoculars that you can picture, right? You'd stand up and be able to look. There was a little a crest out there, which essentially called it a park. For all intents and purposes, it was a public park at the far end of Long Wharf. BRA comes to an agreement to lease the end of Long Wharf, turn the open-air pavilion into a building, an actual structure that would house a private restaurant. And so Sanjoy Mahajan and a group of residents known as the North End 10 in the North End of Boston challenged that decision. The way they challenged it getting here to the SJC was to appeal a Chapter 91 license issued by DEP. That's why DEP is listed as the defendant here. And essentially what the plaintiffs were arguing was DEP can't issue that Chapter 91 license until the legislature has granted its approval through a 2/3 majority vote to allow for this change in use, this transfer of the property. The lease essentially was a transfer is what we were arguing. So ultimately, the issue here before the SJC was the property taken for Article 97 purposes, and the court held no, it was not. And the reason was that there were a number of reasons for the BRA's taking. As I mentioned earlier, one of them really had to do with Article 97 purposes, but the overarching purpose of that plan that really sort of underlaid the taking was not Article 97. So the court looked at this use of the end of Long Wharf as essentially ephemeral, like it wasn't something that was always going to be necessarily the way that was used, and therefore not protected by Article 97. Now, one point before I move on from this, because I think this is pretty interesting. There's history here. So when the end of Long Wharf was developed with that open-air pavilion and some other aspects of the development of Long Wharf, BRA accepted funds from the federal government under the Land and Water Conservation Fund Act. When you accept funds under the LWCF, you have to have what's called a 6F map, which essentially outlines for the National Park Service, here's the area in which we're going to use your funds, and this is the area that is going to be restricted moving forward. And the map that was before the Supreme Judicial Court did not include the end of Long Wharf as having been part of the area for which LWCF funds were accepted. The Supreme Judicial Court issues its decision. A former NPS employee living down in Philadelphia sees this reported in the newspaper, calls the NPS office and says, I was involved in that case. That's not the right map. The end of Long Wharf was definitely included there. And that led to further litigation in federal court. The NPS essentially reversed its position and said, nope, you can't build out there after all. BRA sued them and lost in federal court. So had the Supreme Judicial Court had the right map in front of it, I think we might have had a different decision, as the Smith v. City of Westfield case illustrates for us. So Smith v. City of Westfield. This case involves a piece of property commonly known as the Cross Street Playground in Westfield. It was taken for, I believe, again, tax title purposes. And that was back in the late 1930s. It was fairly shortly thereafter converted to a playground. So you had a playground area, you had ball fields, you had soccer fields. Full disclosure, I grew up in Westfield. I played Little League Baseball at the Cross Street Playground. I played soccer there as a kid. So I'm very familiar with the area. There was a school administration building on the property at the time I was a kid there. But other than that, it was recognized as a playground with playing fields. And you can see here that the city took a number of steps through the years that really pretty clearly designated this land for those purposes. And one of the things they did here in 1979, again, extremely relevant to the ultimate decision, is that the city accepted and used LWCF fund money in the development of that property. As part of that process, they needed to actually check boxes on an application form and subsequent forms saying, yep, Article 97 protected. Yep, we'll always designate this for open space use. It had been, again, through history, identified that way over the decades until 2011, when and this is a pretty common story here in the Article 97 context, the city needed a new elementary school. They had a lot more school-age kids. They needed a new school. They looked at this property and decided, perfect spot for an elementary school. There's a school administration building out there. We're going to need more space than that building allows, so we're going to knock down the playground, and we're going to build a school building on top of it. Transferred to the school department, 2012, demolition begins. 24 residents of the city of Westfield and the neighboring city of Holyoke sue Westfield, arguing that the city needed to go through the Article 97 legislative approval process before they could proceed. The Superior Court issued a preliminary injunction to stop the city from proceeding, but ultimately that preliminary injunction was vacated, and the Superior Court said that the city could go ahead. The reason for that holding was citation back to Hansen and to Mahajan, saying there's nothing recorded in the chain of title for this property that says it's Article 97 purposes, or it's been designated for Article 97 purposes, so no Article 97 protection. The residents appealed further to the appeals court. So we get to the appeals court. First issue, was the playground properly dedicated to trigger Article 97 protection? Answer from the appeals court, no. It was never specifically designated for Article 97 purposes. Issue 2, does the statewide comprehensive outdoor recreation plan, or SCORP, contradict the Mahajan case at all? The answer was no. Mahajan really applied only to lands devoted to public use. No contradiction there. So really, again, what the appeals court ultimately pinned their decision on was a reading of the Hansen and Mahajan cases discussed earlier, which in the court's view required something in the chain of title recorded at the Registry of Deeds for a property clearly saying it was taken or acquired or subsequently dedicated to Article 97 purposes. If you couldn't go to the Registry of Deeds and find something in that chain of title, no Article 97 protection. Now, in my view, that was contrary to some of the language in the Mahajan decision, but that's what the court ultimately decided. Justice Milkie, in his concurrence, a very well-worded and thoughtful concurrence, flagged the problems with his reading of the judicial precedent here, and said essentially that our hands are tied. The appeals court's hands are tied here. Hansen and Mahajan tell us something needs to be recorded in the Registry of Deeds. He didn't see anything in the language of Article 97 requiring that. He flagged a number of practical problems that would stem from that type of an interpretation. Primarily, I think the one that really resonated with me, that just made sense to me, is that if that's the way we're applying Article 97, more often than not, a municipality won't know that a property is not designated for Article 97 purposes until it's too late, essentially. And you see here his language at the end. Justice Milkie feared that the effect of Hansen and Mahajan and the way they were being interpreted by the courts was to essentially render Article 97, if not ineffective, largely ineffective, or rob it of many of its purposes. So he essentially, in my view, invited a further appeal. He was essentially pleading with the Supreme Judicial Court, clarify this for us, this can't be right. That's my editorial interpretation of Justice Milkie's concurring opinion there. So it was appealed further. The residents did appeal further to the Supreme Judicial Court. And amicus briefs were filed by a number of environmental organizations, as you can see here. Mass Audubon, Mass Land Trust Coalition. I authored an amicus brief for MACC, the Mass Association of Conservation Commissions, CLF. The Attorney General jumped in with an amicus brief and ultimately actually argued half of the plaintiff's time before the Supreme Judicial Court. Sanjoy Mahajan, lead plaintiff in the Mahajan case, also filed an amicus brief. All of these organizations supporting essentially Justice Milkie's concurrence and the plaintiff's case. So the arguments we made for MACC, I think, pretty well cover or capture the arguments made by the parties generally. First and foremost, as Justice Milkie had identified in his concurring opinion, there's nothing in the language of Article 97 that requires anything to be recorded in the chain of title to trigger Article 97 protection. Article 97 is meant to be broader than the public use doctrine. It's intended to provide an extra layer of protections there, and that interpretation of Hansen and Mahajan essentially had the opposite effect. We also argued that that Hansen case, which, as I mentioned earlier, had kind of a unique set of facts, really should be limited to its facts and wasn't good precedent for courts to be looking back to in deciding Article 97 cases moving forward. This recording requirement would really place a very, very heavy burden on municipalities. It's costly, difficult, requires a lot of manpower. Effectively, what they'd be asking municipalities to do is go back through their stock of conservation land and piece by piece, parcel by parcel, determine whether there was, in fact, something in the chain of title which would confer Article 97 protection, and if not, take the necessary curative steps to make sure that protection was in place. That's a really major undertaking for municipalities. I'll tell you, a lot of cities and towns started doing that on their own following Hansen and Mahajan because they were worried that something like what was happening in Westfield could happen in their town as well. We also pointed to the language in the Mahajan case, which made very clear that in the SJC's view, even if there wasn't a taking or other acquisition of a property for Article 97 purposes or subsequent dedication, like a conservation restriction, you could look at the way that property had been used over the years, and it just might be that you'd learn the municipality was in fact using this for Article 97 purposes for decades and decades, and that might be enough to confer Article 97 protection as well. So you don't have to have something recorded in the registry. Finally, in the Westfield case, it seemed crystal clear to us that the city had time and again over the course of decades designated the Cross Street Playground for Article 97 purposes. If it didn't apply here, where would it apply, essentially, is what we were arguing. So the SJC's first issue was essentially whether the only way to designate land for Article 97 purposes is through a deed, conservation restriction, order of taking, something in the chain of title, again, as the appeals court had determined, that's going to clearly identify for anyone visiting the registry that this property is acquired for or designated for Article 97 purposes. And the court said, no, there's no recording requirement here. Municipal land may be designated for Article 97 purposes in a number of different ways. You don't have to have something recorded at the registry to have that protection in place. The court looked back at the language of Article 97 itself and really ultimately focused on this one piece, this one provision here. Lands and easements taken or acquired for such purposes shall not be used for other purposes or otherwise disposed of, except by the 2/3 vote of the legislature. That being understood, that codification of that common law doctrines, and especially the public trust doctrine, as I said before, really Article 97 really intending to provide additional protections beyond that, not just limit it to that. And they did agree with Justice Milkie here that interpreting Article 97 otherwise as having some sort of a recording requirement would be contrary to the intent of the legislature and the voters. So really what the court tells us is that you need to look at the totality of the circumstances, and you need to see whether the municipality has demonstrated somehow a clear and unequivocal intent to designate land for Article 97 purposes. And they don't necessarily give us a list of ways that that could happen, but they do tell us that you're going to have to look at the totality of the circumstances. So again, you're not just going to the Registry of Deeds. You're not just looking at town meeting votes. You're not necessarily just looking at the way the property's actually been used. You're going to look at all of these things together to try to understand better what not only the intent originally was for the property, but what's been demonstrated as the intent since then. The second issue that the court looked at was whether the cross-street playground itself had been designated to Article 97 purposes. And the answer here was yes. The playground was subject to Article 97 protection, and therefore they vacated and remanded the prior decisions of the appeals and superior courts. So in considering the totality of the circumstances, again, reviewing courts should be looking at all relevant facts. In this particular case, the acceptance and use of LWCF funds was sufficient. It clearly triggered Article 97 protections in the court's view, and that was all the court needed to see. So they didn't go beyond that to necessarily give us, as I said, a list of ways in which a piece of land might be subject to Article 97 protection. That's what we're going to need to try to find out moving forward here in subsequent court decisions. But here, acceptance and use of those LWCF funds was enough. And that's why I mentioned earlier, had the Supreme Judicial Court in Mahajan had the right map in front of it, we might have had the same decision back in 2013. So since Smith v. City of Westfield, what have the courts done? As I mentioned before, we're now going to have to look moving forward to court decisions to try to fill in some of the blanks left as to what exactly would be enough to demonstrate that clear and unequivocal intent that the Supreme Judicial Court's telling us we need to find for Article 97 purposes. So we have a couple land court decisions since the Mahajan decision, and really that's about it. There hasn't been an awful lot of case law citing back to Mahajan since its decision. We do have this land court case decided a little over a year ago. Mirkovich, I think is how you pronounce it. That's how I'm going to pronounce it anyways. In this case, Town of Shirley came to acquire property as part of a land swap. The deed, and this is going to really be what you're going to be hearing a lot about from Kathleen shortly, what deeds should say, again, like the more practical aspects of this. But in this case, the deed conveyed the property for the purposes of protection of water resources and other compatible purposes, including conservation and recreation. So the question here is whether that land had been taken for Article 97 purposes or designated for Article 97 purposes thereafter. And the court found that it did not have Article 97 protection, although that language in the deed looks pretty good for Article 97 purposes, right? I think most people would look at that and think, hey, you're probably covered. What the court here determined is that because the property's zoning district allowed for a number of other uses that had nothing to do with Article 97 type purposes, and because the deed allowed for compatible purposes, including conservation and recreation, it was not enough. The language of that deed in the land court's view allowed for other types of uses beyond Article 97 type uses. So that language isn't sufficient. And this is, again, you'll be hearing from Kathleen, ways in which you can really tighten up the language of those deeds to make sure you're not finding your municipality or your municipality is not finding itself in a situation like we have here, where you think you had Article 97 protection, but you just didn't really tailor that language quite tightly enough. A more recent decision in September of this year in the town of Sudbury v. MBTA cites to the Westfield case. It really is not an Article 97 case. This is a case where the town of Sudbury has sued the MBTA. There is an old railroad right-of-way. The right-of-way is being leased to NStar Electric Company. Eversource is going to run power lines underground along the right-of-way and then work together with DCR to put a rail trail on top of it. Town of Sudbury sued. The argument here was really public use doctrine, so it's related to Article 97. This case cites the Westfield case, but it's not a pure Article 97 case. The land court in this case found that the town did have standing to bring its claim, but didn't state a claim upon which relief could be granted. Eversource is a private corporation. was the court's reasoning. And the prior public use doctrine is intended to be enforced against public entities. You can't enforce it against a private entity, is what the land court said here. So no relief for the town of Sudbury from the land court. Town of Sudbury has appealed to the appeals court, so to be continued. But those are the two decisions, as of the time I was leaving my office yesterday, that we have following the Westfield case. So again, still, I think a lot of blanks to be filled in with respect to what it actually takes to satisfy that clear and unequivocal intent standard, looking at the totality of the circumstances. So a few practical tips here before I turn things over to Kathleen. When your city or town is contemplating a sale, change in use, other disposition of Article 97 land, or I should say of open space that you think is subject to Article 97 protection, what can you do to figure out whether it is in fact Article 97 protected land? Well, look at the chain of title. Okay, we know after the Smith v. City of Westfield, there's not a requirement that there be something in the chain of title designating land for Article 97 purposes. But that's still the best place to start. Because if you have an order of taking or a deed, or as I said before, some subsequent action like a conservation restriction, which is very clearly designating this land for Article 97 type purposes, then that's going to be the best evidence you could have. If you don't have that language in the deed, order of taking, or some subsequent restriction, look to see whether there's been any acceptance of state or federal grant money which would limit that use. So we learned in the Westfield case, LWCF funds are almost certainly going to confer Article 97 protection. As I mentioned before, one of the things that was striking to me in the Westfield case is that in applying for those funds, the city of Westfield checked a few times boxes saying, yep, Article 97 protected land, yep, nope, we'd never use it for anything else, no problem there. And then came to argue, oh no, it's not Article 97 protected. Those statements in those applications mean nothing. Don't worry about that, Judge. So LWCF grant funds applied for, granted, accepted, used on a property, that's going to almost certainly confirm Article 97 protection. There will also be a project agreement associated with that you'd want to take a look at, because that's going to require a whole other set of hurdles for a municipality to clear with the federal government. NPS and the Secretary of the Interior will have something to say about land that their funds have been used for being put to another use subsequently. At the state level, the Urban Self-Help Program, which has now become the PARC program, Parkland Acquisitions and Renovations for Communities program, similar to the LWCF. If your municipality has accepted and used those types of funds for a property, also very likely to confer Article 97 protection as well. If you don't find anything there, go to Town Hall. Look back through the town records, look at old town meeting actions, other formal dedications. Was the care, custody, and control of that property ever conveyed to a conservation commission, park department, some other similar local board? If so, you're in a pretty good spot to start cobbling together an argument that the actual use of this property has been for Article 97 purposes. And then finally, just common sense. Again, the court has told us we're looking at the totality of the circumstances here. It's not necessarily just one discrete action. Now again, if there's something in a deed or order of taking that designates land for Article 97 purposes, great. But if we don't have that, the Supreme Judicial Court has made clear to us there could be, over time, a number of actions that cumulatively are going to be enough to trigger that Article 97 protection. And again, I think that's what this language in the Mahajan case really was intended to say. The ultimate use to which that land is put might be the best evidence of the actual purpose of the taking. In other words, just because it's not in the order of taking, just because it's not in the deed, doesn't necessarily mean you can't have Article 97 protection. That concludes my portion of the presentation. I think before I hand it over to Kathleen, we'll just take a few questions if anybody has any. Yeah. Maybe, but not necessarily. So CPA funds very often would be used for Article 97 type purposes. And typically, if CPA funds are being used, one would expect that the deed or order of taking would really specify what those funds were being used for. Any related town meeting votes or other local votes would, again, provide good evidence of Article 97 purposes. But I could imagine there might be some expenditures of CPA funds that wouldn't necessarily be for purely Article 97 type purposes. So I think it would depend, but if it is pretty clearly an Article 97 type use, then yes, I would say I think that's really good evidence of the purpose and intent of that initial acquisition of the property. Not necessarily like that. The key with the LWCF fund or the park or urban self-help, the application materials and the ultimate grant documents and project agreements that come out of those, they always really nail cold, in my view anyways, what the purposes are. And it's virtually always Article 97 related purposes. That's not necessarily going to be true of an expenditure of CPA funds, but as I say, more often than not, you're probably going to have a pretty good start to that argument if property was acquired with CPA funds. Yes?
If you had even a very good documentation of the intended use for Article 97 protection, can you speak to the strength of that protection, given the fact that a town can go to the legislature by 2/3 vote of both houses to overturn that use? How many times does that actually happen?
Sure, good question. And the answer is it happens pretty regularly. And by what I mean by that is the bills that are introduced to the legislature pass. They almost always pass. If there's replacement land being provided, then in my experience, I'm not sure I've ever seen one of those actually fail. There have been a few instances that I'm aware of where there was no land being provided as sort of a swap. There was nothing to replace the land that was going to be converted that they failed. But generally, if it gets to the legislature, you need that 2/3 vote. It being a political question at that point, I think that most folks up on Beacon Hill think, well, I might need a vote like this for my constituents at some time in the future. So if that municipality and their representatives are okay with this, who am I to stand in their way? I mean, that's my sort of editorial take on it. There is, in addition to the legislative approval requirement, EEA has a land disposition policy, which municipalities also are going to be called on to comply with. Now, there's nothing that can legally require a municipality to comply with that land disposition policy, but if a municipality does not comply and takes land out of Article 97 use and designates or uses it or transfers it for other purposes, they're not going to be eligible for state grants moving forward. So that's sort of where the teeth come in on that EEA land disposition policy. And without listing out for you everything that requires, that actually requires replacement land be provided and substantially equivalent replacement land, so not just some wetlands that nobody's ever going to build on anyways, a number of municipal approvals. So the EEA disposition policy is another level of protection. If a town's hell-bent on getting property out of Article 97 and they don't think they can comply with that disposition policy, as I said, they could just go ahead, but now they're risking their ability to actually get grants moving forward. I don't think it requires a unanimous vote, but it would require a vote approving it. It would require a Concom approval.
2/3.
And selectmen as well.
You're transferring custody, so it's a 2/3 vote of town meeting.
Yeah. Yeah, it's not, compliance with that EEA policy is no small thing. It's difficult to do. There are some major hurdles in there, but it wouldn't be a unanimous vote. Yeah.
Question on Article 97, any water resource and water supply protection lands have Article 97, and then as far as for park, again, I understand a lot of the background, and then as far as parkland, does that involve all recreation, passive and active recreation, or is it?
Yeah, so in terms of what type of use could be put to a property, yeah, passive or active would generally qualify for Article 97 protection. So it doesn't, there, you know, there's not a requirement that it only be passive recreation or anything like that. Those, yes, those may well have Article 97 protection. It's not, there's no guarantee, but yes, depending on the history there, it may well be.
And then any lands owned by the water department to protect the watershed, is that what they're required for? Well, I guess that standard doesn't apply here.
Well, yeah, again, I would say, you know, I think the Murkovich case is sort of speaks to that, where not necessarily, you know, I guess one would hope that if property is being acquired for protection of those water resources, it would really be specified and the language would be tight enough that you couldn't find yourself in a Murkovich type situation where the court says, well, yeah, those were some of the purposes, but zoning allows for industrial and commercial use there too, and I don't see anything in the deed saying you couldn't do that, so sorry, no Article 97.
There's three mass general laws that cover water department are, I know conservation is 48C, mass general laws.
I'm sorry, what was the question?
I think there are three mass general laws that cover park,
Oh, yes, yeah.
conservation, and water. So if any of that language is citing that, those mass general laws, then that's language that covers.
That's helpful, and certainly if you have a deed or order of taking which is specifically referencing state statutes which are clearly Article 97 type purposes, then that's going to really strengthen the case that the deed actually does sort of does list Article 97 purpose. Yeah.
You said tighten the language of the deeds. So if we have a piece of property that already has a deed, we want to modify the language from one use type to another. So
I'm going to ask you to hold that conversation because I think Kathleen's going to go there. So, yes.
Yeah, I'm sorry, I'm just trying to make sure I saw a couple of different things on the slide.
Sure.
Care, custody, control being a requirement or very beneficial towards getting to Article 97. So if we were to designate something as a park without necessarily transferring care, custody, and control, would that make it eligible for Article 97?
Again, it might be a factor in favor of Article 97 protection when you're looking at the totality of the circumstances, but in and of itself, that's not going to be enough. And I think that really is what the Mahajan case tells us, is that simply saying, yeah, that's a park, without more is not necessarily going to be enough.
And essentially, I mean, where this all comes out is when someone tries to do something. You know, you say, well, we think we're Article 97, and then they look at it and they say,
That's right, and that's exactly what Justice Milkie was driving at in his concurrence. And I mentioned earlier, I think he very wisely noted that very often when municipalities realize there is no Article 97 protection, it's too late, and it's for exactly the reason you just mentioned. It's, you know, the ship has sailed at that point if you're having to go back.
you had two different slides here. I just want to make sure I'm clear. One of them just indicated care, custody, and control to the Concom, and then another one expanded that to include Parks Department or I believe one other entity.
Yeah, so I think there are, the Concom in my view would be sort of the strongest example of dedication for Article 97 purposes. And what a lot of people don't realize about conservation commissions is that the Conservation Commission Act predates the Wetlands Protection Act. So initially, conservation commissions were created to essentially be stewards of conservation land. And once the State Wetlands Protection Act was promulgated and came into effect, Concoms took on a second role of being state, and if the municipality has a wetlands bylaw or ordinance, local wetland permitting authorities. And now we're at a point where I think most people just assume that's a Concom's job, and don't appreciate that Concoms were actually created really for an entirely different purpose that had nothing to do with the Wetlands Protection Act or permitting. I've talked to a number of conservation commissions, and their members were very surprised to learn that. So I think it's just something that people don't fully appreciate. So I think I had on one slide, you're right, maybe just listed the Concom, because to me that's sort of the most obvious example. I think maybe it was this prior slide here where we'd listed some other entities. And the point here is that following Smith v. Westfield, if you're looking at the totality of the circumstances, I wouldn't say Concom's the only local board that would be evidence of Article 97 purpose designation, but it's kind of the most obvious one. Yes, sir.
You mentioned acceptance of the federal state grant money. Applying for that, they may have checked off boxes and said Article 97. So if the property had been designated for a grant, the city has not yet accepted that grant. The state has approved it, authorized it, the state has not actually seen the check. Is that also potentially a factor that could be considered?
It could be considered. It's certainly not as strong. So, I think once you've accepted and used those funds, now you are really subject to the requirements of the project agreement. That there's going to be a project agreement in place, which is going to very clearly restrict what that property can be used for. So the application itself is not going to be as strong evidence as acceptance and use of the funds. Yes, sir.
Is there a specific definition of parkland? In other words, is raw open space, woods with trails considered a park as much as a place that has, swing sets and that kind of thing?
It would be. So I'm not sure there's actually a definition of, as you're thinking of it, I believe, for parkland, but this kind of goes to the question that was asked earlier, passive use, active recreational use, all of those fall under the umbrella of Article 97. And actually, another case I was involved in a few years ago, which wasn't really purely an Article 97 case, but it went to the Supreme Judicial Court. It was the Board of Assessors of the town of Hawley versus the New England Forestry Foundation. And one of the major issues there was whether land owned and held by NEF, New England Forestry Foundation, could qualify for certain tax benefits under the charitable tax exemption because they were essentially holding this land for public purposes, essentially for Article 97 purposes. And what the town of Hawley was arguing is, no, they can't because we don't think they have sufficient access for the public to that property. And what the Supreme Judicial Court made clear in that case is, you don't necessarily have to allow public access for conservation land to still have it contribute to conservation purposes. And one of the arguments we made, which the court picked up on, is that there are certainly instances where the very purpose of attaining land and putting it under conservation protection is to make sure that people aren't there trampling all over it. It might be so sensitive that allowing public access or unfettered public access would actually be harmful and sort of contrary to the purposes of conserving it in the first place. So that, active use, public access requirements, those aren't necessary for Article 97 protection. Either instance, you could have it. Yes?
Address cases where, there's not a change in use or an acquisition, but the public use has been degraded. For example, the Ipswich River is pumped dry by water. Fish all die, you can't do anymore. Is that a violation of public trust doctrine? Is that a stretch?
Well, it may well be, and I think it would depend on the facts, but if what you're saying is that the sovereign or the government in charge of or sort of charged with protecting that property for the public's benefit in the public trust is not doing a good job, is essentially being ignoring its responsibilities there, then yeah, I could imagine you might have a cause of action in that case. But again, I think that would be really sort of a very fact-specific situation. Yes.
I think this was earlier on in the presentation, and I had it in my notes, but I can't remember exactly which cases in reference to, but talking about public prior use as a factor. Can you say more about what that means? I mean, is that just informal
So what it really boils down to is it's very similar to Article 97 type protections in a lot of instances, but essentially it is property that is held or controlled by state, local government, has natural resource values connected to it. So waterways are very often sort of an obvious example of where public trust doctrine would kick in. And essentially, it's the same type of requirements. If the municipality or the Commonwealth is not doing its job, or is allowing that property to be put to some other use, or transferring it for some other use, then citizens may seek to enforce the prior public trust doctrine against, again, the Commonwealth, to ensure that it continues to be used for those public purposes, essentially, is what it boils down to. I'm not sure if that, yeah. Okay. Well, we could chat after if, yeah. Yeah. Yes, sir.
Did you say that New England forestry was protected under Article 97 in that case?
So that was not an Article 97 case. I mentioned it only to sort of illustrate the point that you don't necessarily have to have public access to conservation land to have Article 97 protection. So I was really mentioning it more in the context of, passive versus recreational type use, but that was, yeah, okay. Yes?
I have one question. This actually relates specifically to the Westfield case.
Yeah.
On one of your slides, you had a map showing the land itself, and you had mentioned that there was previously a school administration building on the property.
Yeah.
Was the property school property that they were trying to change hands? Like, what was the ownership?
No, it wasn't. It was, it had been transferred to the Parks Department, I believe. Let's see if we can get back here. So the Playground Commission. So it was under the sort of full charge and control of the Playground Commission. There was a school administration building on the land generally, but it was sort of distinct from, like across a parking lot from the playing fields and the playground and so forth. So I mention that only because I think that's the existence of that building is, I think, partly what helped the city to believe we can do this. Sure. Seeing no more questions right now, I'm going to hand this off to Kathleen. Thank you all very much.
So sit nearby, because when the questions are coming, you have notice. Hi, I'm Kathleen O'Donnell, and unlike my name tag, and apparently I'm listed, I'm not working with Luke's law firm. I work for my own firm, and I'm on the board of the Mass Land Trust Coalition, which has been mentioned a couple of times in other sessions. I'm also on the board of the Community Preservation Coalition, which is the organization that helps community preservation committees. So I should figure out how to get to... Thank you. So as I said, full disclosure, not working with Luke, although I work with that firm a lot. So now that we've had the discussion about Article 97 from Luke, I'm actually, does that actually?
It's recording.
Oh, it's
Yeah.
recording. Is that we've already gotten sort of the history from Luke about Article 97, and I'm really talking about the practical applications of Article 97. And so first, always the question comes up, is this property protected under Article 97? And as in so many things in real estate, you have to read the deed. That's the first place to start. And as Luke had mentioned in that land court case, beware of deeds that list too many uses. And this is the same issue we have with Community Preservation Act funds. Too many uses in an article, too many sources of funds will defeat an idea that is protected under Article 97. So if you have a community preservation vote that says we're acquiring this property for parks, open space, affordable housing, and historic preservation of something, you're going to be defeating the Article 97 purposes for a lot of that parcel. So you have to read the deed first, and or the order of taking if they took it by eminent domain, and then check the title. Is there something on record? Now, in the period of time between Hansen v. Lindsay in 2003, was that the right year? Yeah. And that was a case handled by my former law firm, Kopelman and Page, and they lost. And so after that case, the decision came down, that had a couple of problems with it. The vote of town meeting required the recording of a deed, and the deed was never recorded. The Conservation Commission never listed this property as something that they owned. There was no sign saying, "Welcome to conservation land, take a walk, look at a bird." None of that. It was tax title parcel, and it was just tucked back in something, and nothing was ever done. No use, no dedication, no signage, no nothing. So after that case, the recommendation was that if we had a town meeting vote that was transferring, for example, tax title parcels to the Conservation Commission, we would get a certified copy of that town meeting vote, and we would record it at the Registry of Deeds with an attorney's affidavit, so that there would be something in the chain of title that would show that town meeting voted to move this from tax title to conservation. And that, of course, when Luke was making the argument to the SJC about the expense of requiring a recording, that's $125 every time you walk into the Registry of Deeds, and you've got to do the work. You got to hire the lawyer to do it. And if that's just one parcel, you can imagine if you're trying to do that with like 20 or 30. So that sort of requirement imposed on the cities or towns was really pretty tough. But as I said, so we did have a period of time until the Westfield case where we actually did record these certificates of vote of the town meeting to sort of put something in the chain of title. Obviously, if there's a property that has a restriction, as we listened to the earlier session on conservation restrictions, I mean, that's a pretty obvious thing. Properties that are purchased by a town using CPA funds, and there are now 175 cities and towns that have CPA. If they buy land with CPA funds, they are required to put a restriction on record. And either affordable, historic, or conservation. That is an obligation in the statute. Well, it's interesting because DOR, the Department of Revenue, has been the one that's been responsible for monitoring the community preservation committees, which is something they are not happy about, is that they are now saying if we take a look at your specific city or town and you have not done those requirements, we're not going to give you your funding the next year. So they're talking about sort of saying, if we're going to have a checklist that's going to say, have you got your conservation restrictions that you're required to do? I represent a town in the South Shore. We partner with Wildlands Trust for our acquisitions with CPA, and we now have, I think, 35 conservation restrictions sitting at the Commonwealth waiting for approval, because we're going to make sure that we've complied with the statute. So we don't have any questions. If we go in for a land grant or something like that for a matching, and we haven't proved that we've complied with the statute, we're going to have some trouble. So cities and towns are kind of being told by everybody that, you're really going to have to step up and do that. The other,
I just want to add that I called the coalition.
Yeah.
And inquired that none of our purchase parcels had gone the route in the last 7 or 8 years and added conservation restrictions. The conservation parcels have an historic goes through their preservation agreements, but parks are just in wax and not doing it.
Yeah, the parks is a problem, just sort of as an aside. Recreational use is a new addition to the Community Preservation Act. It was like last time we amended it. They added active recreation. It wasn't in there before. And the problem is trying to find a holder. If you have to remember with real estate, if I own the land, I grant a restriction to somebody else, that's great. That restriction's enforceable. If I somehow, I merge my ownership so the conservation restriction and the land are owned by the same party, interests merge and the restriction disappears. So a conservation restriction from the town to itself isn't any good. It has to go to a third party. And so the problem is, you know, when we vote on open space acquisitions and, you know, going forward with, you know, trying to make sure we've protected the properties too, is that we need to find a holder for that restriction. And it's, you can partner with Essex Greenbelt. There's a cost involved with that, but that's, you know, they're great. They do a terrific job. They're a terrific partner. Wildlands Trust is a terrific partner. Local land trusts step up all the time to be holders of restrictions. But the problem is that the athletic associations aren't that organized for that. And so that's been a problem, is that trying to find a local organization that's active recreation, because a land trust can't hold it. That's not part of their purposes. So it has to be held by an active recreation organization, and in a lot of cities and towns, it's hard to find an organization that'll do that. So that's the delay on the part of the active recreation.
But I've seen your projects, though, you do have
Yeah,
athletic associations.
but it's harder to get that. They're not as organized as local land trusts are. But let me get back to the points that I'm trying to make here, which is that you have to read the deed, you have to check the title to see what's going on, and then the important thing is read the acceptance and town meeting or city council votes that are recorded with the deed and the order of taking. So, for example, you can't just walk into the registry of deeds and record a deed to a town of the smoking hazardous waste site that you own and then argue that the town owns it. That would be a really clever idea, but it doesn't work. There has to be an acceptance that's on record. Years ago, we had a fight with the MBTA over a rail property that was acquired by this town for a rail trail. And so it was a rail trail, and then there was a field that we were going to use for soccer. So we have a town meeting vote that accepted the soccer field, but not all the rail lines. The MBTA included the rail lines in the deed to the town and then said we were responsible to clean up all the hazardous waste. And we said, not so fast, because the town meeting vote voted to accept the soccer field, and there wasn't any mention of all of the rail lines. And just because you added them in there doesn't make us the owner. So when you have a deed that's coming into a town for a piece of property, you need to see, where's the acceptance? Acceptances by conservation commissions don't require town meeting votes unless they're spending money. So if you're gifting land to the Conservation Commission, town meeting doesn't have to approve that, but the acceptance by the Conservation Commission has to be recorded. And so that makes sure that everybody knows that this is conservation land. The Conservation Commission knows about it, and they're excited to get it, and the Board of Selectmen approved it. So that has to be on record. Yes?
I just wanted, the accept by an acceptance, do you mean a certified copy of the vote?
No, it's a vote. It's an actual form that says acceptance of deed. And then it gets signed and approved by the Board of Selectmen. It gets recorded with the deed. Yes?
So if a parcel in a subdivision that in the planning board decision was to be transferred to the care, custody, and control of the Conservation Commission, let's say that never happened, the town ends up acquiring that by tax title taking, is there any way to transfer that to the commission without a town meeting vote?
No. Because the question is about custody, and that's a really interesting concept. I practiced real estate law for a long time before I went to work for municipalities and cities and towns. And so you're like, what? Custody? What the heck is that? Well, it turns out everything in a town is in the custody of some board or organization. So tax title parcels are very frequently a source of open space parcels. But you have to vote to transfer the custody from the treasurer for purposes of sale to the Conservation Commission for open space. And that has to be a vote at town meeting. And the treasurer has to vote first that it's surplus to her. She doesn't need it. And then town meeting has a 2/3 vote to transfer it from the treasurer to the Conservation Commission. And to be good, you would want to record that, maybe, just to make sure everybody knows about it. So, if it's a deed to the municipality, this is actually the best example of language that you would use in a deed. So it's to the town, acting by and through its Board of Selectmen, to be held under the care and custody of the Conservation Commission for open space and recreation purposes pursuant to General Laws, Chapter 40, Section 8C. And conservation commissions can only hold land for conservation purposes. They can't hold it for something else. So that's how a deed should read. Unfortunately, that's not always the case. And as I mentioned, and as Luke did also, the Community Preservation Act requires that any real property interest acquired by the municipality with CPA money must be protected by a permanent restriction. And these permanent restrictions are approved by the Commonwealth. If I just get a conservation restriction and it's signed by me and I deed it to the town, it's only good for 30 years. It can be renewed potentially for another 20, but that's not a restriction that's been approved by the state. And so it'll expire after 30 years. So you want to make sure that you've gone through the approval process. You can delegate management to a particular board or commission, and you can also have a land trust be the, a holder of the restriction or be in charge of the management of the parcels. I always advise, for those of you who are members of land trusts and you're working with your local community preservation committees, is that I always suggest that when the vote goes before a committee for an open space purchase, they don't just vote the sale price. They vote in enough money to cover a survey, a management plan, potentially an endowment, other kinds of associated costs. So if you are working with a community preservation committee on an acquisition, make sure that they ask town meeting for enough money to cover those kinds of associated costs. So this is an example of what a warrant article would look like for the acquisition of open space under Chapter 44B, the Community Preservation Act. And we like to make sure that it's going to be a fee simple. As I said, it's 25 acres. We're describing the land. And further, that it's held under the care, custody, and control of the Conservation Commission. And this would authorize the selectmen to sign any kind of management agreement, a restriction, execute any documents that are necessary for that purchase. And then we've appropriated money from the Community Preservation Fund. In some instances, we'll say in these warrant articles which dedicated fund we're taking the money from. And I think that goes towards Luke's argument about the fact that if you have the indicias of other kinds of language and other kinds of actions that would support the dedication, if you had in here that it's Community Preservation Open Space Fund, I think that would help with Luke's argument about protecting it under Article 97, because you've taken the money from a particular pot. And then, as I said, sort of generally that they're going to be granting a conservation restriction. So that's if you're doing a new purchase. So let's talk about a little bit, and then I know there's a lot of questions on this issue, and so there'll probably be more questions than slides. So what if the deed doesn't read the right way? So these are examples that I have here of deeds that were, a mess. People thought that it was conservation land, but the deed just read, grant to the inhabitants of Fenwick, period. Nothing else, not even an address. So it's just saying to the inhabitants of Fenwick, well, whatever you think it is, it's not conservation land. So a grant outright to the inhabitants of the town or just to the town, doesn't say anything, is assumed to be a grant to the Board of Selectmen or the city for general municipal purposes. And that's where that's going to sit. So, how to fix this? You already have the property owned by the town or the city, so you would need, as I said, a town meeting vote or a city council vote that's going to transfer the custody to the Conservation Commission. And transferring custody takes a 2/3 vote. And then, as I said, you could, it's not required, but I'd probably want to do it as a good idea, is to record an affidavit from the town clerk that attaches a copy of the town meeting vote and says that this is helping to clear the title, and now I've got something on record in the chain that says, okay, this has now been moved from the selectmen for general purposes to the Conservation Commission. It's not a requirement to record that as a result of the successful decision in the Westfield case, but I still think that it's a good idea. Wouldn't you?
Yeah, absolutely. I mean, that's, as I was saying earlier, you still start with the chain of title. There's
Yeah.
nothing in the Westfield case that says we don't care about the chain of title anymore. It's just that's not the exclusive way to determine our voice.
Yeah, I mean, and I said, I mean, it really, in the Hansen case, going back to bad facts make bad law, that was a tax title auction that the collector was holding. And so she never had anything on her cards, a little index cards, because we represented the town, I know what this looked like. She had a shoebox with little index cards of all the tax title parcels. And so she decides she's going to auction it. And the interesting thing is, it also points out that you don't want to be working in the town as the town administrator and then decide to bid in on a town parcel at an auction that you've discovered is buildable, but you're the only one that knows that, and you pick it up for like $100. Not a good plan. So there's all kinds of nonsense going on in the town of Hanson on that one.
Just a quick question. You said it requires a 2/3 vote of the city council to transfer custody to Conservation Commission, but is it also required to transfer, say, to Parks Department?
Yeah. And transferring any custody of is 2/3. No matter where it's going, it has to be a 2/3 vote.
My question is, there are a lot of, not a whole lot, but several cluster developments where open space residential design, where the developer kind of jumped the gun and where he's required to give open space as Clinton filed a deed at the registry with or without the proper language. And my question is, if it's Conservation Commission land, you don't necessarily need a 2/3 vote. The selectmen can accept a donated gift of land. And so can you ask for a vote during a regular meeting and then get a certified copy of the minutes and record that?
I'm trying to figure out, I mean, in cluster zoning, you have to set aside open space. It's a requirement. So you get smaller lots, and then you get to do that because you've set aside a chunk of land for open space. There's a couple of different ways that's sometimes handled. One, and it kind of depends upon the planning board that's approved the plan. In some instances, the planning board doesn't want the town doesn't want to own it. It's useless to them. Lots of times, it's open space, but really, not very much. And it's not so great. And so the town will say, well, have a homeowners association and have the homeowners association own the open space as part of the project. That's where we get into this woman's question about nobody paid the taxes on it, because that happens all the time. And then it becomes a tax title parcel. But the zoning and the permit require that to be open space. So you have kind of a zoning violation or a permit violation if you haven't, in fact, complied with the open space cluster. It says 9 times out of 10, that kind of zoning says it has to have a conservation restriction or it has to be owned by the town under the Conservation Commission. So you have a zoning problem because you're not in compliance with the permit.
I mean, it's not tax day, right? I mean, the assessors have accepted it as town.
Yeah.
But legally, there's no language or acceptance of vote.
Right, but it's,
In the deed, and the developer's gone.
yeah, but it's part of the permit that was required. So, you could,
It's in the decision.
yeah, so you'd still have to have the vote of the Conservation Commission and record it.
And the selectmen to
Well, the selectmen just have to approve it. They don't have to. It's going to the Conservation Commission. The Conservation Commission accepts it. The the approval is just given by the Board of Selectmen to say, yeah, go ahead, Concom, knock yourselves out. Yeah. No, no, it's a form. It's a form of acceptance of deed. And so it's signed by the Conservation Commission. It's really simple. It says, Conservation Commission hereby accepts the attached described parcel. In this case, it's already recorded, so you'd say the Conservation Commission votes to accept the land described in deed, dated, book and page, blah, blah, blah. Yeah. So you could be able to find it. So, going back to mistakes. So, as I said, so there is a grant to the town of Fenwick for conservation purposes. No vote, no acceptance. As I said, it's not owned by the town. The town might want to say that it does, but lots of times when you see these no votes, no acceptances, somebody walked in, and gave you a piece of junk that you didn't really want. So as I said, in the cure, you're going to record an acceptance by the Conservation Commission back to the recorded deed. So the next one, you have a grant to the inhabitants of the town of Fenwick under the authority and control of the town of Fenwick Conservation Commission. That's kind of sloppy, but it works, because the Conservation Commission can't hold land for any other purpose. So even if you don't say for open space purposes under Article, Chapter 40, Section 8C, the only thing the Concom can do is hold land for Concom purposes. And I thought that Luke's point about Conservation Commissions was really interesting, because we all both know that talking to Conservation Commissions, they're so overwhelmed by taking care of orders of conditions, that the whole idea for why they were founded in the first place is gone. And people I know, volunteer on the Conservation Commission because they think they're going to be taking care of open space, and they're like, if I have to look at another drainage basin, I'm going to shoot myself. So it's a sad thing. So lastly, we have a grant to the town of Fenwick. Said property be managed and controlled by the Conservation Commission. It's understood and agreed that the town may use the premises for purposes other than conservation. You just gave it away. Absolutely, and so that's going back to the case that, that Luke had mentioned. Dedication, if all else fails, can you show this? Smith and Westfield, there's no recorded deed to the city, no recorded restrictions, but you bought the land with CPA money, you just didn't get the restriction yet. It's shown on the municipal plans as open space. You've got signs on it saying it's a park. You've got walking trails, you publish walking maps, you have a harvest festival, you name it, it's there. You've got grant funds from a state or federal program, and the donor, I had a situation just recently, a case in Nantucket, where the Boy Scouts wanted to sell off part of it to a developer. And the deeds in the chain of title were, this is sold to the Nantucket troop of the Boy Scouts, and if the Nantucket troop stops using it, it comes back to the donor. That's a charitable trust. So you have to read those deeds. Sometimes somebody will say it's used for this purposes, and if it stops, I get it back. And those last longer than 30 years. And the last part is that I would caution you all that lots of time, town councils are not real estate lawyers. They have labor, they do contracts, they do all kinds of things. They don't practice real estate law. And most real estate lawyers, I can say as a former president of the Real Estate Bar Association, don't do land transfers to towns. So getting the deed right is not that simple. Town councils sometimes don't know how they're supposed to be worded, and the attorney that's representing the seller to the town doesn't know either. So that's why I gave you the example of what the perfect language should be in a deed. And I think that's my last slide. So I know there's probably a lot of practical questions you folks want to ask, and so I'll use up the rest of my time with that. Any questions? Yes?
On that example for Fenwick, for the right language, transferring conservation under, 48C,
Yeah.
it said open space and recreation. Like, and my question goes back to, that under the Conservation Act, that's just passive recreation, right, not active.
Right.
So it could be, okay.
Right.
And then a second question, if a parcel of land was given to the town, transferred for
Yep.
And it was never, park department or, you know, and it never was constructed. That gets us that nebulous area.
Yeah.
Because it was transferred for a playground. But never
Right,
had
but
that.
yeah, I mean, it was transferred, and it hasn't changed. So you could argue, I don't know, Luke, what do you think about that? Where you didn't actually build it.
Yeah, I would say that I think in that instance, the fact that the deed
Yeah.
or order of taking is specifically calling that out is really probably going
Yeah.
to be a very good indicator that Article 97 protections exist, even though the thing was never built. That's not quite
Yeah.
the same as like the Hansen case where there was a
No,
town
nothing.
meeting vote to accept the deed, but there never was a deed. I think that's sort of the opposite
Yeah.
situation.
Right.
With the open space cluster
Yeah.
conversation we were having, and the land is supposed to be transferred to the Conservation Care Custody and Control. The homeowners association owns it. They don't like the language of the restriction that was written, so they won't sign it. And you said there's a zoning violation in there somewhere.
Yeah, I mean, it was
How do you enforce that?
well, I mean, I'm a real estate lawyer. I do real estate transactions all the time. So I'm reading the title, and it says, okay, here's the special permit, whatever, and there's a requirement in the special permit. I'm going to have a problem representing a buyer and representing a bank, because wait a minute, what do we do about this?
There's no certificate of compliance with the subdivision either, because
Yeah.
when there's a certificate of compliance, there's no planning board and street acceptance,
Yeah. That happens a lot.
but they still sell.
Because a lot of times people don't read stuff. Lots of times you'll see a restriction that gets recorded at the registry of deeds, and it won't be listed as a restriction. It'll be listed as an agreement or something, something nebulous. The statute, interesting on restrictions, use has a requirement that the registry of deeds is supposed to keep a separate volume of restrictions that are recorded at their registry. And no, to my mind, none of the registries have ever done that, and certainly haven't done it since. Yes?
I have a couple questions that are linked, and one I think you've already answered, so just to confirm. So there's no such thing as like a generic Article 97 protection. It's really that care, custody, and control is an essential feature of it, correct? Could you, the example that
Yeah.
we've consulted about with where the city already owns a property for general municipal, looking to put some protection on it, could you invoke Article 97 without transfer of care, custody, and control to?
Well, you have to say that you're doing, you have to transfer custody. You can't just say, Article 97 is here.
Right.
You have to, because the language, as Luke points out, says, acquired. There's no acquisition there.
So that was my assumption, and I sent that question in advance.
Yeah.
So given that with the model that we were looking at in Amesbury,
Yeah.
for a large parcel where it would kind of have, under the general protection, have the use zones, and so
Yeah.
some areas would be for passive recreation and conservation purposes, and some would be for active recreation. And so we, kind of spell those out, sketch those out. If that was accepted, is it the case that in the future, should the city and the city council decide to amend the layout of those zones, the meets and bounds of those use zones, would that just be the same kind of process to accept it in the first place, 2/3 vote? They could rearrange expand, say, the active recreation?
I
all
think,
within the
so we were talking about this large parcel, because Luke doesn't have the background on it.
Yeah.
So there's a large parcel with some
farms.
with some farms. So it's owned by the city, but no designation. So the idea would be that you have this huge chunk. Some part of it you might want to have for active recreation, and some you might want for passive. So the idea was, and I've done this with CPA purchases, that we do a vote that transfers the property from the city for general municipal purposes to conservation, parks, as designated on an attached sketch plan. But those are all Article 97 purposes. So, if you were then to say, okay, fine, I want some of this to be open space moved over to, you know, a lacrosse field, I don't think that triggers an Article 97 situation, because it's all Article 97.
Right, in
but
other words,
different
you're
purposes.
sort of changing from one Article 97 use to another Article 97
Yeah.
use. Yeah, I think that would be all right. You know, one thing I would just point out with respect to sort of the first question you asked there, in terms of designating care, custody, and control and who actually has that, which municipal board has it, I don't think there's anything in any of the cases we've discussed or anywhere that I'm aware of that says a property must be under the care, custody, and control of, say, a conservation commission for Article 97 to apply. It could be that the property is held under the care, custody, and control of the school department
Right.
or the select board. And it's used for Article 97 purposes, and we accepted LWCF grant fund money for the development of that parcel. That's Article 97 protected.
Yeah,
So
right.
the question of who has care, custody, and control is relevant, and it's especially relevant if you don't have anything in the chain of title or any other clear designation. That's one of those factors you'd look at for the sort of totality of the circumstances. But just because it's not held by, say, the Concom, doesn't mean there's no Article 97
Yeah.
protection.
So this, with the city as the mayor, you know,
Yeah.
the executive, continue to hold it, but the purposes were spelled out in the order, voted on by 2/3 of the city council, kind of with defining the uses, Article 97 uses throughout, that could still kind of
Yeah.
attest the protection.
I think so.
I agree.
2/3.
Why would two-thirds vote be required if you're not?
Because you're changing the custody.
No, but we're saying we're not changing it.
You are changing the custody, you're changing the purpose of the custody. So, for example, when I've had tax title parcels that are owned by, you know, they're held by the Board of Selectmen, because they're the ones who own tax title parcels in that town. I'm now gonna sell them for some other thing. I vote to transfer the custody from the Board of Selectmen for general municipal purposes to the Board of Selectmen for purposes of sale. So you're changing the purpose. So it's still held by the Board of Selectmen right now, it's held by the city under general municipal purposes. You're gonna vote 2/3 to move it to the board, to the city council for these associated purposes. That still needs a 2/3 vote. You're changing the you're changing the purposes.
Okay, and,
As long
Yeah.
as it says solely for those purposes.
Exactly.
I'm sorry, I'm somewhat new, but I want to make sure I get the language right. So I've always been clustering those three together, care, custody, and control, but you're actually separating them and saying you're changing custody at this point, not necessarily care and control.
Well, it's care and control, but for the purposes are different. You don't want, it's still held by the city's still the owner of the land. You don't want them owning it for general municipal purposes. You want them to own it for open space, recreation, whatever. So that's a transfer of the kind of custody. I'm not owning it for general purposes, I'm owning it for this. That needs a 2/3 vote.
Does that require NEPA too?
No? You're not doing, you're not changing any use.
Yeah, again, if it's a change from, yeah,
Yeah.
right, there's no change in use. I think that's, the land, if you're talking about sort of the land disposition policy we were talking about earlier. But if it's from one
Yeah.
Article 97
Yeah.
type use, so let's say my municipality owns a 50-acre parcel of land for open space
Yeah.
purposes, and we decide, you know what, we want to put some hiking trails out there. We don't, right now, there's no way for public access. We want public access. It's appropriate for it. Let's put hiking trails. You're now allowing a more active recreational use, but it's still Article 97 purposes.
Yeah.
There's no change in the use, really.
Right. Yes, question?
The term open space, passive, active, are they terms of art, or are they defined legislatively, or legal doctrine?
There,
It really is it absolutely necessary to list every conceivable, possible passive versus active? Or if we happen to miss one, is that the loopholes, and we say, well, you didn't count walking trails, you didn't say walking trails, you can't put walking trails. I'm just trying to
Well, mostly the difference is, and I think there have been cases, and I think there's also sort of regulations from DCR and stuff like that. So passive is that you are not really changing the terrain. So you can put in walking trails, you can put in little bridges over streams, all that sort of stuff. That's for passive recreation. You are not bulldozing the field, flattening it out, putting in lights, a stand, and a concession stand. That's active recreation, which I'm doing for a ball field. So when you say passive, you're not, it's passive because it's not, the activity itself is passive. I'm not laying there reading a book, but that you are not actively changing the terrain, the vegetation, all that sort of stuff. It's not the activity so much as to what you are bulldozing when you're using it. And I have a minute left. Let me take a question from somebody who hasn't asked one, and then I'll stay up here.
Doesn't passive use also include that there's no motorized use?
You have to sometimes take a look at the restrictions. If there's an actual restriction, we'll talk about that. Whether there's motorized use, most of the time there isn't, but there's a real push to make sure that there's some part of a park that's accessible to disabled people. You don't want to be saying that no, people with a motorized wheelchair can't go anywhere. That's not very good. So, you want to make sure that you're not, as I said, bulldozing things, but you have to think about that. And lots of times that's handled in a management plan, handled in a restriction as to what you're going to allow.
My question was on, I never think I understand, but the Mahajan Park in Newton, like
Yeah.
years ago.
Yeah.
It was parkland through the public works, but the public works then used it for snow dump and
Right.
material handling and contract yard. Those last three aren't Article 97 uses, right? So that,
No.
in that case, was that resolved internally or did?
Yeah, I think so. Yeah, I think so. I think so. So thank you very much for your attention.